Hi, my name is Raymond Kiswani and I'm a partner at Davison & Co. We are a law firm with offices in Dubai and Geneva, and we cover a wide range of practice areas from corporate commercial, dispute resolution, employment, private client and wills. I head up the international trade practice here at the firm, where I advise clients on a wide range of issues, including insurance, logistics, maritime, commodities, trade finance, energy and aviation, as well as retail, hospitality and F&B. I also advise clients on sanctions, anti-money laundering and anti-bribery regulations. As a brief background about myself, I am a UK and US educated lawyer. I'm qualified as a solicitor advocate in England and an attorney at law in New York. I'm also fluent in Arabic. I've been based in Dubai since 2014, and before joining Davison & Co, I worked at an international law firm, and prior to that, a leading UAE law firm. Before moving to Dubai, I worked in an insurance and trade law firm in New York City. The reason for this video is that we have been receiving a substantial amount of inquiries on business interruption insurance. And on the 15th of September, there was some breaking news and very important developments in relation to business interruption insurance, which could significantly affect businesses in the UAE. Most businesses, and particularly small to medium-sized enterprises, or SMEs, have some form of business interruption coverage. As the name suggests, business interruption insurance is insurance coverage for when a business is unable to operate. Usually, business interruption claims arise from property damage. For example, a fire that causes a restaurant to close for repairs would enable the restaurant to submit a claim to their insurer for business interruption. The typical disputes that arise between a policyholder, i.e. the business owner, and the insurer is over the amount of the claim. A business would have to demonstrate the amount of losses it has suffered due to the closure, usually by showing how much business it brought in the past during a similar time frame. The question that many business owners are asking us is whether they can claim for business interruption insurance as a result of the COVID-19 outbreak and/or the various governmental lockdowns and restrictions. Many businesses, in particular those in retail, hospitality and F&B, have suffered a tremendous amount of losses due to COVID-19, especially in a place like the UAE, which has a thriving restaurant, hotel and retail sector. And unfortunately, it will probably become as no surprise that many insurers have disputed or even rejected claims for business interruption as a result of COVID. On the 15th of September, there was a very interesting judgment out of the High Court in London on this very topic. This was a test case that was brought by the Financial Conduct Authority, or the FCA, which regulates the insurance industry in England. And the case was filed against 8 leading insurers. The purpose of this test case was to determine issues of principle on policy coverage and causation under sample insurance wordings. The FCA represented the interests of policyholders, many of them being SMEs. During the proceedings, the High Court considered well over 20 sample wordings of business interruption policies. Now, the judgment is complex. It runs well over 150 pages and it deals with many issues. However, by and large, the High Court decided in favor of policyholders that indeed the sample policies do provide coverage in the circumstance of COVID-19 outbreak. Now, it is important to note that this case might be appealed, and more importantly, this is an English court judgment and has no legal effect in the UAE. Now, that said, this is a significant case for UAE policyholders for several reasons. First, Due to the nature of the insurance market in the UAE, business interruption policies in the UAE will have very similar, if not identical wording, as those policies reviewed by the High Court. In fact, most of the insurers in the London case provide insurance coverage in the UAE. Second, insurance policies in the UAE are governed by UAE law and are subject to the jurisdiction of the UAE courts. UAE insurance law and the UAE courts usually lean in favor of policyholders in circumstances of ambiguity found in policy wordings. Third, UAE businesses faced significantly more onerous lockdowns and restrictions than businesses in the UK, including criminal liability. Now, that was certainly necessary for public health reasons, and the UAE has done and continues to do significantly better in its COVID response than many other countries. However, businesses, especially those in retail, hospitality, and F&B, which the UAE is well known for, suffered considerable interruption to their normal operations. For those reasons, we are of the view that UAE businesses have a meaningful advantage in claiming for business interruption from their insurers. It is extremely important for businesses that have suffered interruption to their operations to obtain legal advice from an expert insurance lawyer as a matter of priority, since all insurance policies will have stringent notification requirements which could affect a policyholder's ability to claim. We here at Davison & Co. typically advise businesses on insurance from renewing a policy to interpretation of an existing policy, as well as putting forward claims and any disputes with insurers, including filing court proceedings should that be necessary. If you do have any questions, please do feel free to contact us and we will be more than happy to assist you. Thank you.